Charles Peabody welcoming you to this edition of the Ologos News Network with your host, Bishop Abouna1. This is Charles Peabody asking you to stand by for some breaking news.
What you are about to see is astounding evidence, and it is in the congressional record, that Barack Obama may have been purposely placed in the White House as an unconstitutional president. It now appears that this placement was done to effectually end American supremacy in the world and perhaps usher in a new era of global Marxism. This video will prove that from 2003 through 2008, members of Congress, most of them Democrats, feverishly worked to eliminate Article 2, Section 1, Clause 5 of the United States Constitution, requiring that all presidential candidates be natural-born citizens of the United States. This was all done just prior to the rise of Barack Hussein Obama to the office of President of the United States. This video focuses on the period from 2003 to 2008 and the political maneuvers that took place in order to pave the way for America's first unconstitutional president. Starting in 2003, Democrat members of Congress made no less than 8 attempts in 22 months to either eliminate the natural-born requirement or redefine natural-born citizen. Note that each attempt to redefine or eliminate the natural-born clause goes to the elimination of the requirement that the president is born to 2 legitimate American citizens. Following are the 8 congressional attempts to circumvent the Constitution and pave the way for an Obama presidency. Number 1. On June 11, 2003, Democrat House member Vic Snyder introduced H.J.R. 59 in the 108th Congress. Its wording declared that it was to be a constitutional amendment making a person who has been a citizen of the United States for at least 35 years and who has been a resident within the United States for at least 14 years eligible to hold the office of President or Vice President. On September the 3rd, 2003, Representative John Conyers introduced H.J.R. 67, another constitutional amendment proposal making a person who has been a citizen of the United States for at least 20 years eligible to hold the office of President. On February the 25th, 2004, Republican Senator Don Nichols attempted to counter the growing Democrat onslaught aimed at removing the natural-born citizen requirement for president in Senate Bill 2128. It was entitled the Natural-Born Citizen Act. It defined the constitutional term natural-born citizen to establish eligibility for the office of president. But Senator Nichols got the definition of natural-born citizen wrong. That Senate bill was voted down. The 4th attempt came on September the 15th, 2004, as Barack Obama was about to be introduced as the new savior or messiah of the Democrat Party at the DNC convention. It was H.J.R. 104. It was introduced as yet another proposed constitutional amendment, making eligible for the office of president non-native-born persons who have held U.S. citizenship for at least 20 years and who are otherwise eligible to hold such office. The 5th attempt came on January the 4th, 2005, H.J.R. 2, to the 109th Congress. It was again a proposed constitutional amendment, making a person who has been a citizen of the United States for at least 20 years eligible to hold the office of president. Attempt number 6 was on February the 1st, 2005, H.J.R. 15, making eligible for the office of the president non-native-born persons who have held U.S. citizenship for 20 years. The 7th attempt came April 14, 2005. Representative Vic Snyder tried yet again with H.J.R. 42, making a person who has been a citizen of the United States for at least 35 years and a resident of the United States for 14 years eligible to hold the office of president. Attempt number 8. All of the preceding efforts failed in committee. The 2008 presidential election was now looming with an unconstitutional candidate leading the DNC ticket. Democrat Senator Claire McCaskill tried to attach an alteration to a military bill in Senate Bill 2678 on February 28, 2008. It was entitled Children of Military Families Natural Born Citizen Act, declaring that the term natural-born citizen in Article 2, Section 1, Clause 5 of the Constitution would include any person born to any U.S. citizen while serving in the active or reserve components of the U.S. Armed Forces. DNC presidential candidate Senator Clinton and DNC presidential candidate Senator Obama were co-sponsors of this bill. From June the 11th, 2003 to February 28, 2008, a span of 6 years, there had been 8 different congressional attempts to alter Article 2, Section 1, Clause 5, the Natural-Born Citizen Clause in the United States Constitution. All of this took place during Barack Obama's rise to political power and preceding the November 2008 presidential election. But finally, on April the 10th, 2008, unable to alter or remove the natural-born citizen requirement to clear the way for Barack Obama, the U.S. Senate acted to shift the focus. Just before the election, they introduced and passed Senate Resolution 511, declaring Senator John McCain to be a natural-born citizen, eligible to run for and hold the office of president. Interestingly, his citizenship was never an honest question, but Barack Obama's was. The sponsor of the resolution, Democrat Senator Claire McCaskill. Senate Resolution 511 states that John McCain is a natural-born citizen, and the conditions for that declaration were by virtue of the fact that he was born on American-held territory to 2 current U.S. citizens. This would be a condition not even met by Barack Hussein Obama. DNC presidential candidates Hillary Clinton and Barack Obama were co-sponsors of this resolution on John McCain's citizenship status. Obama would know that even he could not meet the definition of this Senate resolution. When House members asked the Senate to hold similar hearings on Barack Obama, the Senate refused. However, but here is the key, in the McCain resolution is also this language, quote, whereas the term natural-born citizen, as that term appears in Article 2, Section 1, is not defined in the Constitution of the United States. This would be the phrase that would be used over and over by the Obama camp and the Congressional Research Service to prop up the clearly unconstitutional president. In November 2008, Barack Obama wins the presidential election. But just before the presidential election, with questions and doubts swirling from coast to coast concerning Obama's constitutional eligibility, Obama's legal team now spends well over $1.4 million blocking access to every single identifying document of Barack Obama, from his birth to his travels to the White House. Just a few days before Obama is sworn into office, Obama meets with the Supreme Court justices, 8 out of 9 of them, in a closed session meeting. This was done while there were now cases pending before the Supreme Court concerning Obama's eligibility. Justice Anthony Scalia was strangely and unexplainably absent from this secret meeting. No reporters were allowed. No attorneys were invited on behalf of the plaintiffs who had pending cases against Barack Obama before the Supreme Court. Many legal experts consider this move to be highly unethical and perhaps illegal on the part of the Supreme Court. And as a result, to date, the Supreme Court, nor any other federal court, or any court for that matter, has heard a single case on merit concerning Obama's citizenship challenge. For 2.5 years, Obama refused to release a birth certificate identifying his constitutional eligibility. In April 2011, Obama finally released his purported long-form birth certificate. But since then, numerous computer and document experts have concluded that the birth certificate that Obama released is a forgery and a fake. To date, not a single expert has come forward proclaiming the document to be legitimate. General Paul Vallely has recently proclaimed publicly that the birth certificate is a fraudulent document and Obama should be impeached. These are the facts. Now it's time for we the people to act.
behalf of Bishop Abouna1 and the entire staff of the Ologos News Network, this is Charles Peabody saying thank you for joining us and have a very pleasant evening.
For me and you, and I think to myself, what a wonderful world.